Dear students, welcome to lecture 5 of week 4, wherein we have been talking about export sales contract. Today, we are going to discuss on the title, that is dispute settlement mechanisms in export contracts. As we all are aware that disputes do arise in international trade, but it is always very important to focus on dispute settlement mechanism. Let us begin the journey. At the outset, let us go towards the contents of today's discussion. We are going to first of all introduce about the topic, followed by identifying the causes of disputes. After that, we will try to focus our understanding on dispute clauses as well as the prevention strategies. Subsequently, we will try to look towards negotiation and settlement as well as mediation, which includes the concept and process. Subsequently, we will try to throw some light on conciliation and the difference between mediation and conciliation. After that, we will try to focus on arbitration, its concept and process, followed by institutional versus ad hoc arrangements. After that, we'll try to learn the key arbitration bodies that are present as well as the governing law and jurisdiction that is applicable. Finally, we will talk about the international conventions and emerging trends before we conclude the lecture. Dear students, at the outset, remember that disputes are inevitable in cross-border trade, that is, international trades. Disputes may arise due to one or the other factor. For example, the geopolitical changes, changes in exchange rate, changes in the requirement of the buyer, changes in the pricing, any of such factors can become a reason for dispute. Having disputes in international trade is a daily cup of tea. However, this needs to be resolved. That is what the problem is. They are The disputes arise due to complex legal, cultural, and operational factors that operate in the international trade. The another important reason which we can cite in introductory remarks is that effective dispute resolutions are required to solve this problem. If disputes are properly resolved, then cross border trade will not only improve, but there will be continuity in the trading environment and trust building between the exporters and importers. Thus, a well drafted dispute clauses can prevent litigation and protect the commercial interests of both the buyers as well as the sellers. This may further create an business environment of trust between exporters and importers, thus facilitating the trade between two or more countries. Let us now try to identify some of the causes of export disputes and what are their nature. There can be contractual breaches. That is, if already a contract exists between buyer and seller. This is the contract C. And any of the clause of contract has been broken down deliberately or maybe not deliberately between these two by any one of them, then it will fall under the category of contractual breach. It may also include non delivery of the goods at the specified time. It may be delivery of goods but with defective goods. It may also be some kind of payment defaults or payments mismatch according to the contract. This may raise several disputes between the parties. The second cause of dispute may be the interpretation issues. Though export contracts should be free from any ambiguity, The language should be agreed upon. That is, if the contract is in English, then interpretative language will also be English. But still, in certain scenarios, there may be some dispute because of interpretation. So the ambiguous terms should not be there, but it happens sometimes. So that may also become a reason for export disputes. The third cause for disputes may be certain external factors. For example, geopolitical factors between two countries. There may be some tussle between the political powers of two countries, and because of that tussle, this particular effect may spill over on the companies and exporters as well. We can take the example of Russia Ukraine war and tussle. So because of that, the Ukraine firms are not able to export to Russian Federation directly. So they are exporting to other countries, and then rebranding happens and the goods reach to Russian Federation. So such type of things do happen because of certain external factors. These may also include sanctions that are put by multilateral organization or any particular country on other countries, and certain regulatory challenges and certain regulatory changes as well. Then we have the operational challenges which accentuate the disputes. Delays, logistics failures, documentation error can all lead to disputes, because in that scenario there is nobody as fault except that carelessness of the two parties may be there. But ultimately, because of that carelessness and errors in documentation, there may emerge disputes between the parties, that is exporters and importers, that is buyers or sellers. Let us now try to understand that why it is important to resolve the disputes. And for resolving disputes, the first step is that dispute resolution clauses should be present in export contracts. The first important reason is that the dispute resolution clauses define the process of how dispute will be settled, venue, and law governing the dispute resolution. As well as the second point under it includes that the dispute resolution clauses prevent the jurisdictional uncertainty and costly litigation. Similarly, dispute resolution clauses also ensure faster resolution of the disputes, as well as the disputes that can be enforceable easily. And finally, dispute resolution clauses also provide business continuity, because once disputes are sorted out or minimized or resolved, then the trading between the parties may continue. This continuity in business operations is very important for sustaining businesses in the long term as well as short term. Also, if dispute resolution clauses are present in the export contract, they can be reason for developing long-term trade partnership between countries, because this creates an environment of confidence, trust, and predictability between the buyers and sellers, that is the different parties involving in the international trade. Dear students, let us try to identify and appreciate the different dispute prevention strategies. We already know a popular adage that prevention is better than cure. So, is there a way through which we can prevent disputes? Yes, these are known as dispute prevention strategies. What steps need to be undertaken? The first is there should be a clear draft of the export contract. It should be comprehensive and precise so that disputes does not arise. Second, there should be due diligence on conduction and behavior of the trading partners, that they should behave in accordance with the terms and conditions. The third important prevention strategy is to establish regular communication and monitoring mechanisms. At times, communication solves most of the misunderstanding between exporters and importers. But what happens? Exporters become so busy in economic matters, financial matters, and expansion and diversification of the business that they forget the communication strategies of the business. Therefore, communication can prevent disputes because communication removes the barriers of understanding. Thus, communication should never be undermined in a particular contract. And third, the prevention strategies, they are use standard trade terms and international conventions to reduce interpretative disputes. Thus, it means that the exporter and importer should try to look towards the international convention so that they can take cue from them that how to mitigate the disputes that may arise in the future. Let us now try to focus on negotiation and settlement approaches. Negotiation is considered to be first line of defense because with negotiation both the parties can come on a table and agree on certain matters. Direct negotiation, in which there is no intermediary, helps resolve disputes quickly because there is no third party. And it is also cost effective because both the parties understand the scenarios. They already understand and have seen the different terms and conditions, and thus it is less costly as well. Negotiation and settlement approaches maintains commercial relations and preserves confidentiality between buyers and sellers, that is exporters and importers. It is only possible through negotiation that parties can modify contract terms, agree on compensation, or arrange substitute performance. Specifically, substitute performance is required to improve the business relation in case certain mishappenings have happened during the course of export and import. Also, we can take a note from this that effective negotiation often prevent escalation to formal proceedings. If negotiation is proper, then it may resolve certain disputes and it may not become legal or formal to such an extent that it goes to legal authorities or courts. Let us talk about another way through which disputes can be resolved, which is known as mediation. Mediation is a voluntary, confidential process where a neutral third party is added to resolve the dispute. This particular third party is responsible for maintaining an environment where both parties can negotiate, and at times when they do not agree on anything, the third party can give possible solutions on which agreement can happen. Also, in this, both the parties that are disputing the issue, they should have full trust on the third party and the neutrality of the third party. Thus, in cases of major conflict on any agreement, the decision may be reverted back to the negotiating third party so as to solve the issue. This is one of the very traditional but good method in which things can be sorted out at the earliest. In the under mediation, the mediator does not impose a decision but helps parties reach a mutually acceptable solution. Mediation is widely used in international trade to preserve commercial relationships. Thus, mediation is encouraged as an early stage dispute resolution tool before arbitration and other legal litigation ways are explored. Let us try to understand the process of mediation. The process of mediation starts from initiation, where parties agree to mediate and appoint a neutral mediator. The second step is the preliminary session, where ground rules, confidentiality terms and objectives of the mediation are set. That is, what are going to be the that is what rules are going to be the point of reference when negotiation is happening between the parties, which is part of mediation. The third step is statements. Each party presents its perspective and the way it looks towards the problem, towards the neutral third party, so that both ways the parties have contributed towards the input of the problem. After that comes a joint discussion or private caucuses, which means a private discussion within the party members itself, where mediator facilitates dialogue, clarifies interest, and explore options through which dispute can be resolved. After that comes the settlement agreement. When consensus is developed between the parties, then the mediator develops a new agreement, which is a settlement agreement, where it is documented that this dispute be resolved in such fashion. And finally, the step is if mediation fails, then parties may proceed to arbitration, that is, other methods of solving the dispute, that is, either through arbitration or litigation in the courts. The next important way in which dispute can be settled is conciliation. Conciliation is a voluntary, non binding method where a neutral third party assists in resolving disputes by proposing solution. Conciliation is more proactive than mediation, and the conciliator may suggest terms for settlement. Similarly, conciliation focuses on a mutually acceptable resolution without any formal adjudication. Thus, also, conciliation is less costly and it can be performed in a short span of time. Often, conciliation is used in international trade to maintain long term partnerships and avoid escalation of disputes to a level of legal litigation. Let us now try to see the step by step process of conciliation. The first step is agreement. The parties give consent to conciliation and appoint a conciliator. The second point or step is information exchange, where both the aggrieved parties exchange their perspective of the problem and they tell each other that what are the evidences for their own claims. The third step is assessment, where conciliator evaluates the dispute and identifies all the possible permutation combinations of the solution. The fourth step is proposal. Conciliator suggests settlement terms for consideration. The proposal may be inclusive or exclusive. It means that proposal may include both the parties' participation or it may include participation from one party or sacrifice from one party. Then comes the step of negotiation. Parties review, modify, and negotiate suggested terms. And finally, it is settlement. That is, agreement is reached and documents are drafted where the conciliation terms are written. Generally, the conciliation terms are non binding, but they can be converted into a contract if parties agree to the same. Dear students, let us now try to differentiate between mediation and conciliation. If we try to talk about the definition, mediation facilitates negotiations, while on the other hand, conciliation facilitates settlement assistance with proposals. With respect to neutral's role, facilitator does not suggest terms. On the other hand, conciliation is proactive and proposes solution. With respect to outcome, if we talk about mediation, there is a mutually agreed solution between the parties. while on the other hand, in conciliation, there is mutually agreed solution, but the proposal of conciliator matters. If we talk from the perspective whether these methods are binding or non-binding, then mediation is non-binding between the parties. On the other hand, conciliation is also non-binding, but if a new contract is maintained based on conciliation, then that particular contract can become binding. Finally, use case, where to use mediation and where to use conciliation. Mediation is generally used in early stage disputes or where parties seek autonomy. On the other hand, conciliation is used in more structured approach or where parties need assistance in finding solutions. Dear students, let us now talk about arbitration. Arbitration is a way of settling disputes. In arbitration, disputes are resolved by an impartial tribunal, that is a legal entity chosen by the parties. They, in international trade, arbitration is preferred because of several reasons. The first is neutral forum. The arbitration organization, which is a tribunal, which has some legal sanctity, is considered to be a neutral forum. Because of its neutrality as well as legally binding approach, it is one of the best ways in which disputes can be resolved. The second is confidential proceedings. At times, mediation, arbitration, At times, mediation, conciliation does not have any sanctity of confidentiality. The participating parties may disclose several of the trade secrets, which may then be passed on by the third party. Because of that reason, confidentiality is achieved in arbitration. Because it is a legal binding tribunal that maintains confidentiality of both the parties. The third important benefit is final and binding decisions. Because arbitration is done by organizations that have legal entities that are tribunals, therefore, the decisions which are taken by arbitration bodies are legally binding, which means that the whole process of arbitration has some final conclusion which is legally binding. On the other hand, the energy and time which is required in mediation, in conciliation, gets wasted if the parties do not follow it because it is actually not legally binding. The next benefit is greater enforceability under global conventions. Global conventions that are used in trade disputes and international trade talks about mediation and conciliation, but the outcome of mediation and conciliation is not considered legally binding. The only thing which is considered legally binding is the arbitration by tribunals. Thus, arbitration becomes very important because it adds value and its applicability is appreciated through international conventions. Under arbitration, parties control the procedure, venue, language, and applicable law, giving mutual benefit to both the parties. Let us now talk about the arbitration process. The first important thing in arbitration process is that is the first step where arbitration agreement happen. There are clauses or separate contract is possible. The second is appointment of arbitrators through tribunals and tribunal constitution, which is going to solve the problem which has become an dispute between the parties. The third is submission of statements and evidences by both the parties. After that, hearings and deliberation happens in the tribunals where both the parties present their perspective of the problem and dispute, and after that there is final award issued where the decision of the court is enforced. Either both the parties are given some relaxation or one party gets a preferred decision over the other. Let us now try to understand two different types of arbitration: the institutional arbitration and ad hoc arbitration. Institutional arbitrations are administered by established bodies like International Chamber of Commerce, LCIA, SIEC, which are all the commercial tribunals, which have certain set rules and procedures. On the other hand, ad hoc arbitration depends on the independent. On the other hand, ad hoc arbitration is conducted independently with parties without any institutional support. Thus, institutional arbitration is more structured and predictable in comparison to ad hoc arbitration. What are the different key arbitration institutions? We have the International Chamber of Commerce, which is the most widely used arbitration institution in the global trade. Then we have the London Court of International Arbitration, which is preferred in European markets. The third is Singapore International Arbitration Center, established at Singapore, which is more preferred in East Asian countries. The next is Hong Kong International Arbitration Center, which is again considered in Asia Pacific as an important arbitration center. So we have ICC at the global level. Then we have London Court of International Arbitration, more used in European Union. All four, all five are globally acceptable. But what is which one is used more, that we are talking about? So ICC is used more globally, then LCIA European Union, SIAC in East Asia, HKIAC in Asia Pacific, and then United Nations Central Arbitration Rule, which is used in ad hoc arbitration independently between the aggrieved parties. Let us now talk about the governing law and jurisdiction clauses. The governing law and jurisdiction clauses are critical for determining applicable legal principles and forum. The governing law specify which country's law apply to interpretation and enforcement. We all know that in international trade, two countries are participating and one country belongs to exporter, another country belongs to importer. So, in terms of dispute, which country's law will prevail? That is an important question. The third important thing under governing law is that having knowledge and information prior to agreements are also very important for the law which will be applicable in times of crisis and if any disputes arise. Then we have the jurisdiction clause. The jurisdiction clause identifies courts or tribunals and authorize them to hear disputes. So, governing laws and jurisdiction clauses totally have some inclusion which ensures predictability and these reduces the procedural delays. With these two benefits, that is predictability and procedural delay, trade facilitation increases globally. The next important issue is litigation in cross-border contracts. There are different traditional methods, but they are less preferred in international trade because of the dynamic nature of international trade. But still, litigation in cross border contracts, there are certain advantages such as judicial authority, appeal options, strong enforcement mechanisms, etc. Similarly, there are certain disadvantages in case of litigation. Litigations are costly, they are time taking, that is lengthy, and public. They are public means everything related to the company or the business will be in the public domain, as well as they are subject to certain local biases or heuristic biases. Litigation often is used for interim relief, enforcement, or when arbitration is not agreed upon. However, as expo- however, as exporters, we should always be vigilant of litigation. We should try to focus more on mediation, more on mutual agreement, conciliation, or arbitration rather going for litigation. Let us now try to focus on recognition and enforcement of awards. Arbitral awards are generally easier to enforce than foreign court judgments. As an example, we have New York Convention of 1958, which ensures recognition on over 160 jurisdictions. Thus, using such type of conventions makes it easy for exporters and importers to resolve their issues. Also, enforcement of such conventions requires procedural compliance but is typically faster and more reliable. If we compare, the limitation with domestic courts may hamper the easy solution because domestic courts may refuse enforcement on limited ground, for example, public policy violations, etc. Let us try to understand the role of different international conventions. Here we have mentioned three major conventions: the New York Convention, United Nations Citral Model Law, and Hague Convention on Choice of Court Agreements. These three are widely used conventions at the global trade. New York Convention is about recognition and enforcement of foreign arbitral awards. On the other hand, Unicitral Model Law harmonizes arbitration procedures globally. And the third Hague Convention of Choice of Court Agreement enhances certainty in jurisdiction clauses. At least last 40-50 years, these conventions have become very successful noted points for dispute mechanism and for arbitration. The benefit of countries in following these international conventions is that more countries can journalize the way a dispute will be resolved. Instead of having different jurisdictions and conventions for every country. Suppose there are three countries A, B, and C. A is following X convention, B is following Y, and C is following Z. But there is an international convention which is M, whose parameters are common. Sum of X is in X, sum of Y is in X, and sum of Z is in X. Which means why not these countries A, B, and C are using M, that is international convention, instead of using individual different conventions. This gives benefit that now these three countries and their exporters and importers can work together because their rules have become same. Thus, international conventions are such frameworks that promote confidence in cross-border dispute mechanism. What are the emerging trends in dispute resolution? We have highlighted four important emerging trends. The first is online dispute resolution. With the rise in technology and online buying behavior, export and import has also become online and digital in process. Now, digital platforms are used for cross border trades. Thus, disputes also arise in digital cross border trades. In order to solve these cross border trade disputes, there are certain platforms, and this online dispute resolution is one such digital platform. The second important dispute resolution trend is the hybrid clauses. The hybrid clauses combine arbitration and mediation. They are in short known as MED-R, where they take help of a tribunal, but they also go for mediation with the help of tribunal itself. Thus, it becomes a blend of arbitration and mediation. So, this is an emerging trend which is coming up in the dispute settlement mechanism. The third is sector specific arbitration. These are tailor made for shipping, construction, or intellectual property disputes because the rules and regulation and dynamic nature of these industries are changing very fastly. And finally, it is expedited procedures which are faster, cost effective resolutions for smaller claims. The same process which is being used as dispute resolution for 1 crore valuation goods and it will be waste of time to use the same resolution mechanism for goods worth rupees 5000. Thus, it makes sense, and the emergent trend is to use such expedited procedures in terms where valuation is very low or it is not that much high. Dear students, let us now focus on a case illustration. Here we have taken an example of International Chamber of Commerce arbitration. The scenario, we have taken a hypothetical scenario. Suppose a European buyer alleges non-conformity of goods against an Indian exporter, which means that the European buyer is saying that what quality of goods was promised to me, these goods are not of that quality. This means non-conformity of goods. What action will be taken? Arbitration will be under the ICC rules, which are governed by English law. Okay. Then what will be the outcome? The tribunal awards damages to buyer, enforceable under New York Convention. And finally, the insights which we get through this illustration that a well drafted arbitration clauses ensure swift, neutral, and enforceable resolution. So, how it was enforced that the whatever damages are there that should be given to the buyer, and then this matter was resolved. Now, this resolution is beneficial for both the parties because they can continue trade between themselves. Dear students, let us now conclude what all we have discussed in today's slide. We have highlighted the importance of dispute resolution and has reached to a conclusion that dispute resolution is a critical element of export contracting, ensuring business continuity, legal certainty, and commercial protection. We have also attempted to understood mediation, to understand mediation and conciliation. And we have reached to a conclusion that mediation and conciliation help resolve conflicts amicably, preserving long term relationships. We have also understood and appreciated the point that arbitration as a legal remedy to solve the disputes offers a neutral, enforceable, and binding solution which is preferred in international trade. We can now take a note that well drafted clauses on governing law, jurisdiction, and enforcement enhance contractual security and predictability. And finally, as global trade evolves, mastering dispute settlement mechanism is essential for exporters as well as importers to minimize risk and strengthen cross-border partnerships. Dear students, thank you very much for being with me in this session.